Sanjay Kishan Kaul was one of the judges of the 5 bench that delivered judgment on Article 370. Justice Kaul served as a judge since 2017 and retired in 2023. And because he retired, he was giving many interviews to the media, and then he is explaining what is the thinking of the court on the issue of 370. So, Justice Kaul explains the basics of what Supreme Court thought in a much simpler and easy way. Okay, so this is worthy of examination because the report that they gave was huge and it's more difficult to go through. So let us see what Kaul has to say. He says, first, he disagrees with CJI on the issue of sovereignty. This is CJI Chandrachud. Kaul says that there was sovereignty. There was a sovereignty. So 370 gave sovereignty. So he agrees with third video I made, or the lesson that I took. So Kaul would say that yes, there was a sovereignty and this cannot be equated with asymmetric federalism. Okay. But then he says 370 was envisaged for progressive assimilation of Jammu and Kashmir, and that is why it was made temporary. Envisaged for progressive assimilation, and that is why it was temporary. Okay, reasonable. And then he says assimilation was going on. Okay, and which meant sovereignty was on decline. Assimilation was going on and sovereignty was in decline. So it means sovereignty was given, meant to be taken away slowly, and it was being taken away, and only some sovereignty left now. Okay, this is how Kaul saw it different from Chandrachud, CJI, who felt there was no sovereignty in the first place. So that is the difference. And next, according to Kaul, what are the issues before the court? He says there were 2 issues before the court. That is it the time to end the remaining sovereignty? Sovereignty was granted, it was on decline, there is something. Is it the time to end? Which means, is it the time to remove the special status? That is the question. And next, is it ended properly? Is it the time to end, and is it ended properly? So to Kaul, these are the issues before the court. Is it the time to end, and is it ended properly? So court, according to him, has to answer in its judgment these two basic questions. That is how he saw the issue. Okay. Next, what in essence were the answers given by the court to these two questions according to Kaul? Is it the time to end sovereignty? Time to end sovereignty. And Kaul says in a very interesting way that the timing to end only government can decide and not the court. And the present dispensation, that is present government, thought it is the time to end. So we can't go into it. Wow. So that is to say, special status can be removed How can special status can be removed? Because it is meant to be removed. And then government can do. So basically, what is the discussion in Supreme Court, if the court is very clear on this? So Kaul saying special status can be removed because it was supposed to be temporary, and government can remove. And he also thinks court can't question. Court can't question. It is a government's decision. So he is taking this ending of special status as a kind of administrative decision by the government, or a political decision by the government, into which court cannot go into. That is how he saw it. So that is a political question. Government can decide, and government can decide existing on its own data, and court cannot go into it. So then what is the discussion about? And next he says, is it ended properly? Then he has an answer. He says, you can say it is ended properly because of the peculiar situation that Jammu and Kashmir was in at that time, that is, with no legislature and like that. Okay, so it is ended properly because of the peculiar situation, because no legislature, and so it cannot be done in some way. Many possible, in only one particular way, many possible ways of ending, and given the situation, it was the way to end it. Okay. So this is what they said. So which means two questions. Can government end? Yes. Because it has to judge the present situation. And two, was it ended rightly? It was ended rightly given the peculiar situation. Okay. So now we are examining these two answers to these two questions. These questions may be right, but Kaul's thinking is, or Kaul's answer is right. Can government end? In fact, how can one assume that the government can end? They are supposed to look into whether the government can end. So the assumption that the government can end, okay, I mean, so that is an issue. And then the present situation is that the government thought it can end. The present situation. He is talking about the present situation. The problem with this argument is, the ending of 370 doesn't have anything to do with the present situation. BJP always wanted, RSS always wanted, Jansangh wanted, and now it is in power, and now it wants to end. It is not that a position is reached that it can be ended. It is not the change in the political position, change in the ground situation. It is the change in the government that has the power to do it. A party which always wanted to remove came to power, and now it thought it fit. So it has nothing to do with the current situation. It has something to do, or everything to do with its ideology. So, do you agree with this ideology? So, Kaul gives the impression that government came to an understanding that the ground situation is right to remove 370. In fact, the variable is not the ground situation. The variable is the regime that always wanted to, that never liked 370. So, it is wrong to say in government's judgment, present situation enabled, because it has nothing to do with the private government's present situation. Everything is to do with the ideology, not the present situation. So, I would say the government thought it right to end given the situation was not right, was not correct assessment. It was the ideology that made it, and Kaul should see whether he agree with the ideology, or Supreme Court agrees with the ideology of the ruling party, BJP and RSS. That's one. Next, second thing is it ended properly? Strangely, Kaul says, given the peculiar situation of, for example, no chief minister, no legislature, only governor. Okay. He says it is a peculiar situation. But the problem with this understanding is that this so-called peculiar situation was created by the government to remove 370. Not that this situation arose and the government was responding. First of all, what is the urgency in removing 370? 370 can wait after this peculiar situation is ended. So peculiar situation is created by the government with a particular ideology. So that is what the logic is. So the idea that this situation is different is wrong, because it is ideology. The idea that there is a peculiar situation of no legislature and no chief minister is also wrong, because the government did all of them to remove 370. Okay. And then even the understanding of the changes since, for example, Kaul says that Article 370 was envisaged for progressive assimilation. Okay, that is very temporary. Assimilation going on, sovereignty on decline, and he says, and there was no problem in this. He says no cases were filed on reduction in sovereignty and assimilation. Okay, but then how do you explain so much of violence in Jammu and Kashmir? Human rights violations. Why was there a problem? So how do you explain political situation if assimilation is willingly going on and the decline of the sovereignty is going on willingly with the consent of the people, just because there were, according to you, no court cases? So what are these arguments? So one person says, CJI says, in the first place there is no special status because it is asymmetric simulation, asymmetric federalism. And then Kaul says that there is a special status but meant to be removed. Okay, this also is agreeable, but then how can we say government is meant to remove this without people's consent? So there is no discussion on what are people thinking. Is their consent taken? If it is called temporary, on what ground it is temporary? When is it supposed to be removed? Is it not conditional to consent? So where is the consent? And without the consent, can this be constitutional? So what is it that I can say about this logic? I can only say, if it was not among the learned judges and if it was not in Supreme Court, I would say all these arguments, amount to trivialization of the issue. Trivialization of an issue that challenged the foundational assumptions of Indian political system from day one. And these judges apparently seem to have no clue to what was the challenge that they were examining and what they were doing to the foundational values and assumptions on which this republic was founded. I'm sorry to say this.